Today I want to talk about Ramos versus Louisiana, decided by the United States Supreme Court in April of 2020. There, Mr. Ramos was convicted of a serious criminal offense by a 10-2 jury, in which 2 members of the jury voted to acquit. Yet the rule in Louisiana, as well as in Oregon, was that a jury could convict someone of a crime even when the jury is not unanimous. In fact, a 10-2 jury verdict is enough to convict. Now, the holding of Ramos versus Louisiana is fairly straightforward. The court held that the Sixth Amendment right to a trial by jury, as incorporated to the states by the 14th Amendment, requires a unanimous jury to convict a criminal defendant of a serious offense. Now, as simple as the holding is, the reasoning and the discussion of this opinion is perhaps the most interesting to me from this term, perhaps only tied with McGirt versus Oklahoma. Justice Gorsuch, writing for the majority, discussed the issues in terms of both history and in terms of precedent. In terms of history, Justice Gorsuch looked at the racial underpinnings of the non-unanimous jury verdict rule in both the states of Louisiana and in Oregon. In Louisiana, following a state constitutional convention, the committee members first imposed this rule in 1898. And one of the reasons they did so is because the state of Louisiana no longer believed that it could keep African Americans off of juries. So instead, they imposed this rule to basically ignore up to 2 jurors in order to water down potential African American votes. Then in 1930, Oregon imposed the same rule at the same time that the KKK was coming into power. In fact, interestingly, in the oral arguments and at the briefing stage in 2019, neither Louisiana nor Oregon denied the racial underpinnings of this rule. Now, Justice Gorsuch, being an originalist, also took a long historical look at the right to trial by jury and what it entailed. What Justice Gorsuch found is that as early as 14th century England, we see the right to trial by jury, including the right to a unanimous jury verdict in criminal cases. We see that in 14th century England. We see this reflected later in Blackstone. We see this in the early colonies. In fact, at the time that our Constitution was written, that was the rule in the United States. It follows then in 19th century legal treatises in the United States, etc. And we don't see these rules starting to emerge until 1898 in Louisiana to water down African American votes, and then 1930 Oregon at the time that the KKK was coming into power. So you have a long history of juror unanimity required in the right to trial by jury. And then you have a short history of these 2 idiosyncratic rules that both have racial underpinnings. Now, this may be an easy decision, but for a bit of a complication, which is a case called Apodaca versus Oregon, decided by the Supreme Court in 1972. There, the Supreme Court took a look at these same rules before and reached the conclusion in a fractured opinion that the rules survived constitutional scrutiny. Looking at the opinion in Apodaca versus Oregon, we see 4 jurors that would have struck down, 4 justices that would have struck down the rule altogether. You see 4 justices that voted to uphold the rule, which became the plurality opinion. And then you have the interesting concurrence of Justice Powell. Justice Powell believed in his concurrence that the Sixth Amendment required a unanimous jury verdict. But at the same time, Justice Powell stood alone in his belief of a dual-track theory of incorporation. In other words, although the Sixth Amendment was incorporated into the states by way of the 14th Amendment, it was only done so in a watered-down form. Therefore, although the Sixth Amendment requires juror unanimity in federal trials, that part of it did not carry over into the states. Justice Gorsuch took a very critical approach of the way that Apodaca splintered, reaching the conclusion that why should we give so much weight through the Marks rule from Marks versus United States in 1977, which held that the narrowest form of a plurality controls? Why should we give that kind of weight to Justice Powell's opinion when in fact the court has subsequently rejected a dual track theory of incorporation? And in fact, Justice Powell himself believed that the Sixth Amendment required juror unanimity to convict. Ultimately, this discussion of precedent became kind of the major argument between Justice Gorsuch and the dissent in Ramos versus Louisiana. But it goes to show that we have to take a very close look at precedent, particularly when we're dealing with pluralities. We see this most recently in a case called United States versus Hammond in 2020, or perhaps 2019, in which the Supreme Court again fractured in Justice Breyer's one justice concurrence right now through the Marks rule is being considered the controlling opinion, despite itself being idiosyncratic. So Ramos versus Louisiana offers a fairly straightforward holding, but a very rich historical discussion, and then a very interesting, intriguing, and perhaps foreboding discussion of the nature of precedent when you're dealing with pluralities.